Hi, Dan Murphy Sr. asked me to give you some background on how some of our more complex litigation is handled at the firm. As you are probably aware, I'm handling a mass tort case for the office right now, and I hope to continue to work on complex litigation matters whenever they come up. You'll probably want to take some notes so you can refer to them later. There are some product liability complaints in the office form bank that contain multiple claims, so be sure to check those out. They'll help you make some sense out of what I'm about to tell you. Mr. Murphy has recently decided to take on a case involving one of his oldest friends, Max Shoemaker, and you and I will be doing some preliminary work on that case, including drafting pleadings. But before I send you off to review the file, I want to talk to you about some considerations when dealing with product liability matters. As I'm sure you've learned in school, product liability refers to the liability of a manufacturer or anyone along the manufacturing chain for injuries caused by a defect in the product in question. Potential defendants could include the manufacturer of component parts, the assembling manufacturer, the wholesaler, and the retail store owner. Unlike negligent cases where we need to present proof that the defendant owed a duty and breached that duty, in a products liability matter, we have a different type of proof. Despite how much care the defender takes while manufacturing or assembling the product, the court may still impose liability when a defective product injures a consumer. A defect may be one that occurred in the design of the product, or that takes place during the manufacturing of the product, or a defect can be the result of a marketing process, such as when the customer isn't giving adequate warnings and instructions. It's important for you to understand that no matter how defective we think the product is, we must offer proof through expert testimony and opinion that there really is a defect. That means working with professionals, often engineers or technical advisors, who can help us understand a product and whether it's truly defective. Handling a product's liability case means that, in a small way, you too become the expert, because you're going to have to learn a lot about the product and how it's made. Another important aspect of complex litigation is the fact that in a lawsuit, we may be bringing multiple causes of action. The product's liability in particular, we usually assert separate claims for negligence, strict liability, and breach of warranty. Drafting a complaint that clearly establishes multiple claims takes great attention to detail and working knowledge of what assertions must be made under the law. If we determine that there are multiple defendants, that makes the job of drafting the complaint a bit more complicated. Again, the sample products liability complaints in the office form bank will help you understand how these claims are worded and organized. Another issue is what law to use. Products liability law is based mostly on common law. In other words, judicial opinion. Article 2 of the UCC, which is adopted in most states, involves the sale of goods and will figure into part of many product liability claims. Some states have enacted comprehensive products liability statutes, and these statutory provisions aren't necessarily the same state to state, even though the United States Department of Commerce has created a Model Uniform Products Liability Act for voluntary use by the states. We may also have to deal with choice of law issues in a product liability or any complex litigation. Since the governing law is state law, which state's law applies? Where the plaintiff was injured? Where the product was manufactured? Where it was sold? These are all the issues that we need to consider before we file a complaint. Right now, the Shoemaker case is just about the injuries our client sustained because the MP3 player earbuds he was using caused a disruption in his pacemaker. But Mr. Murphy wants us to look into whether this could be a class action. If we ultimately make this a class action suit, we'll need to consider one more aspect of complex litigation cases: how to organize and keep track of documentation. Litigation support software may have to be utilized to help us track the amount of information that could be part of this case. So what do we need to do to get started on the Shoemaker case? I'm going to give you a few assignments. First, go to the file and read over Mr. Murphy's memo. It'll give you some more background on this case and how Mr. Shoemaker was injured. You're about to become an expert on how pacemakers work and whether these earbuds can actually cause them to malfunction. Once we have a better understanding on whether there's a defective product, the next step will be to work on initiating the lawsuit. Well, that's about it for now. Please check your daily task list to make sure that you keep up with any assignments I send your way in this matter.